All right, this is Judge Krier again. If everybody would just stay muted until I call your case, that would be great. The first case on my 8:30 docket is Sadler versus First Protective, 20 CA 875. Who's here for the plaintiff?
Good morning, Your Honor. Ian Ansley on behalf of the plaintiffs.
All right, and who's here for defendant?
Good morning, Your Honor. Jason Little on behalf of the defendant.
All right, this is a motion to compel. I believe it's plaintiff's motion, correct?
Yes, Your Honor.
Go ahead.
Essentially, when this motion was filed and when the hearing was set, the defendant was not responsive to our deposition request. However, recently, Mr. Little has been very responsive in the last few days. So we are working out this issue and trying to get these depositions set. I just request that the court enter an order requiring the depositions be set within 90 days. We're on Your Honor's October trial docket, so we'd like all depositions done by the mid-September.
All right, Mr. Little, any problems with that?
No, Your Honor. We've been offering dates up to September, so that should be fun.
Okay. All right, so send me an order, Mr. Freeman, or not Mr. Freeman, I'm sorry, Mr. Ansley.
Will do, Your Honor.
Thank you. All right, next case is Gotthofer versus Progressive, 20 CA 2665. Who's here for the plaintiff? Anybody? How about defendant? Kathy, do you have that they came off the docket?
Yes, I have. I don't have them on my docket.
Oh, okay. All right, next is Bentley versus C of Savings LLC and Crystal Turner, 20 CA 596. Who's here for the plaintiff?
This is Patrick Neal for the plaintiff, Your Honor.
All right, and these are motions to withdraw. Is anybody here for the defendants?
I am the defendant.
Okay. All right, so whose motion to withdraw is this? Is this yours, Mr. Neal?
No, it's not, Your Honor. There was a motion by Mr. Capriotti, and you entered an order on it on the 14th, substituting in Mr. Domerick.
So this is a motion that was filed on May 18th, and it was filed by Mr. Capriotti. So
Correct. Mr. Capriotti, he's the liaison. My actual attorney with the firm is up in Indiana. It's where I'm located. My attorney.
Your actual attorney has to be somebody that either has been admitted pro hoc VK or be a Florida attorney. So you can't have an attorney that's not been admitted to Florida.
Mr. Capriotti is my representation for down in the Florida jurisdiction, but I'm assuming that he thought that we'd be off the docket for today. So maybe that's why.
Well, you actually have to call and get yourself off the docket. So.
And Your Honor, if I may, I'm completely confused.
Yeah.
There was an order issuing, substituting in Mr. Domerick 2 days ago.
Right.
And yet this hearing went forward, and Ms. Turner's here apparently pro se. So Ms.
Turner, you're telling me that Mr. Capriotti is your attorney?
But he is not. Mr. Domerick is now my attorney. He's my substitution in.
Okay, well, why isn't he here?
Mr. Lewis and Brevard, who was my previous attorneys, they never sent him the information. I'm sorry, I'm not aware of all the laws and things that need to go.
You're aware. The problem is this is, a lawyer Rowland and Lubell is a good firm, so I'm not sure what's going on, but you need to make sure that they know about all court dates because they are responsible now and they have failed to appear for a hearing. And or failed to comply with the court's scheduling procedures. So we'll Kathy, just reflect this as moot because there has been a substitution. They just didn't take themselves off the docket. All right, so let me just look and see where you guys are scheduled. You're scheduled for trial in March of 2022.
Yes, Your Honor.
Mr. Neal, do you think you need another case management conference?
Probably would be valuable because we do have new counsel in there. I've reached out to Mr. Domerick because we are scheduled to have an arbitrator agreed upon by the 19th, next Monday. Obviously with new counsel, we may ask the forbearance of the court to give us a few days on that. But
generally speaking, I don't have a problem giving you more time as long as it's no later than 35 days before pretrial.
Yeah, that shouldn't be an issue, Your Honor.
Okay, I'm emailing my case manager to set up a new case management. But again, you can get out of it if you talk to each other and get, if the plan's not any different, then you can issue a stipulation saying the plan's the same, but at least it gives everybody a heads up as to what's going on, since Mr. Dahmer doesn't seem to know what's going on. All right, thank you.
Thank you very much.
Yep. All right, next is Russell versus First Protective, 20 CA 605. Who's here for the plaintiff?
Your Honor, this was canceled late last night,
Oh,
and the
okay.
attorney came on this morning, canceling it for sure.
Okay, good deal, thanks. Next case is 20 CA 902. This is Castillo versus Cleland. Who's here for the plaintiff?
Evan Lubell on behalf of the plaintiff, Your Honor.
All right, who's here for defendant?
Good morning, Your Honor. Doug Zabo representing Ron Cleland.
And
All right.
Susan Cole representing Judy Cleland.
All right. This is a motion for leave to file a second amended complaint. So, Mr. Lubell, go ahead.
Yes, Your Honor, this is exactly that, a motion for leave to file a second amended complaint. The original complaint was filed against the natural grandfather and grandmother. We've learned through discovery that there are similar allegations to be made against the natural father of the minor involved in the case. That is Timothy Cleland. We're moving to amend to add 2 additional counts to the complaint and add Tim Cleland as a party. The counts are for negligent supervision and negligent failure to warn, similar to those counts against Judy Cleland.
Involved in the same incidents, correct?
All in the same instance, all the same, almost the identical theories as Judy Cleland.
Mhm.
I did speak to opposing counsel, and although I don't believe they're in a position to agree to the motion, I don't believe they object either, but I will let them speak for themselves.
All right, Ms. Cole.
Your Honor, I don't have any objection. I don't have any legal objection that I can make to the motion. However, what it does do is throw a wrinkle into the scheduling, because if they're adding a new party, it has to come off of the trial docket. The
Right.
amended case management order and the second amended case management order that is now pending before the court would then be made moot. We'd have to set a new trial date. That's all fine, and my client doesn't have an objection to it, but I just need to be make the court aware that that is what is some of the logistics here.
Okay, Mr. Zabo.
Yeah, similar argument, Your Honor. We circulated a revised or proposed new case management plan yesterday. My only concern is I don't think the current parties can agree on dates without the new defendant being involved in his counsel. I don't think it would be fair to schedule and have deadlines when they haven't even been served, or we don't even know, what their response is going to be. So I think we need to take everything off the dockets until we get that party served, and then everybody can participate in the new case management plan.
Okay, so I'm going to grant your motion. I'm emailing my case manager. I'm going to set you for a case management in September. I'm hopeful that the new defendant will be served by then. Again, you can get off that case management docket by having an agreed plan, whoever he's represented by. And if you need a continuance on the case management for some reason, just let us know. But I just want to make sure we don't lose track of the case.
Your Honor, we have a motion set for tomorrow on a motion to compel better answers to discovery. We have a deposition set in the case. Is all of that stuff going to get canceled as well?
Up to you. You might have to do it again. I mean, I'm not entering a stay, so. But again, up to you. I mean, yeah, it probably means you'd have to do it a second time if you don't cancel it, but that's, guys, up to you. Think you can work that out?
We'll work it out. We've been able to work everything else out, Your Honor.
Okay, good deal. Mr. Lubell, so in order to my office email address in Word format, please.
Yes, Your Honor.
Okay, thanks.
Okay. Thank you very much.
Thank you, Your Honor. Have a good day.
You
Thank
too. All right, next case is Rexxar Flight and Maintenance LLC versus Andrew Aircraft Sales, 21 CA 1036. Who's here for the plaintiff? Anybody? Defendant? Kathy, did they come off late last night?
No.
All right, put them down as a no-show.
Okay.
Next is Island Roofing versus Tower Hill, 19 CA 2895. Who's here for the plaintiff? Anybody? Well, this is looking fun. How about defendant?
You're here. I'm here, Your Honor. Lindsay Burkholz on behalf of defendant Tower Hill.
Okay. Well, this is a motion to determine entitlement to costs and fees, I think, on behalf of your client, correct?
Yes, correct, Your Honor.
Okay. And this case is on appeal from my judgment, correct?
Yes, Your Honor.
Okay. Well, and I believe your request for fees is based on your offer of settlement.
Yes, Your Honor. It's a little bit complicated in that we do have kind of a couple of moving parts here. We had a motion for sanctions, which Your Honor would remember, where we were granted entitlement already to a series of fees and costs as they relate to some specific events, like specific depositions and hearings and motions. But we had waited to determine the reasonableness until we had a ruling on whether there was a more broad entitlement, so we didn't spend all of the judicial resources, taking up the court's time and breaking them apart. So we were hoping to get a more broad ruling on the overall entitlement to fees and costs before we separately broke out the sanctions fees and costs that were already entitled.
Well, I don't have a problem ruling on your motion in terms of the overall entitlement, but I don't want to do reasonableness on the broader entitlement until after the appeal. Now, the other orders, we could ostensibly at some point do a reasonableness hearing because that's based on something else, and I'm not sure that those have actually been appealed. So up to you, but however you want to handle it. But today I'm willing to rule on your motion if you want.
Yes, absolutely. I mean, we'll take a ruling, and then how we want to handle the reasonableness, we can go from there.
All right. Any reason that plaintiff's counsel might not be here? I'm looking to see if it was properly noticed.
There was a separate appellate counsel that was involved in the appeal. However, they emailed us, I think, earlier this week to confirm that we had a court reporter set for this hearing. So there are two sets of counsel, and it doesn't seem like the appellate counsel is entirely sure whether or not the original counsel is still involved in this case. We did reach out to everyone with the, coordination of this. I'm trying to see the date that they reached out to us to confirm the court reporter.
Well, let me tell you, why don't you, I'm going to skip over you and then come back, but if you would make an effort to have your office email them or text them or something and see if they intend to show up, we'll give them another few minutes in this hearing.
Absolutely. They emailed me on Monday to confirm I got a court reporter for today, so I'll give them a quick call.
Okay. So just mute yourself and we'll come back to you. All right.
Thank you.
Thank you. Next is Island Roofing versus Tower Hill, 19 CA 2895. I already called that one, sorry. Did I already call it on? Oh, that was one I just called, sorry.
Yes, Your Honor, that was us.
Sorry. Next is DeRocher versus Castle Key Indemnity Company, 21 CA 733. Who's here for the plaintiff?
Good morning, Your Honor. Laís Negrón for the plaintiff.
All right, who's here for defendant?
Jeffrey Best for the defendant, Castle Key Indemnity Company, Your Honor.
All right, this is plaintiff's motion to strike defendant's answer to paragraph 5 of plaintiff's complaint and plaintiff's motion to strike defendant's affirmative defenses.
Yes.
So go ahead.
Your Honor, the complaint was served on March 5th, and paragraph 5 of the complaint states that all conditions precedent to the filing of this lawsuit have occurred, have been waived, or have been performed. In defendant's answer, defendant denies the allegations contained within paragraph 5 and demands strict proof. Florida Rule of Civil Procedure 1.120C permits a plaintiff to plead performance of condition precedent in general terms. However, if the defendant wishes to deny such performance, then the denial must be alleged specifically and with particularity. If defendants to deny all the condition precedents that have occurred in their answer, then they should either amend to comply with the Rule of Civil Procedure 1.120C, or the denial should be stricken.
All right, response?
Yeah, Judge, if you take a look at our answer in under affirmative defenses, it's paragraph number 26 in our complaint. We set forth with specificity and particularity the conditions precedent that were not complied with. Therefore, I believe we have complied with any trial rules regarding pleading. So I'm not sure what else to do other than it's set forth right there in affirmative defense in subparagraph 26.
Mm-hmm. All right, response.
Your Honor, let me pull up number 26.
Well, the next motion you have is to strike their affirmative defenses. I would think that you know what that is.
Yes, it's not regarding number 26. I'm sorry. I do see their conditions precedents are in number 26, Your Honor.
Mm-hmm. All right, so your motion is denied to strike their response to paragraph 5. All right, in regard to their affirmative defenses?
Your Honor, this motion to strike is on affirmative defenses 1, 2, 10, and then number 3 as well. And those are going to be paragraphs, for the first one, paragraph 20, for the second one, paragraph 21, for the 10th, paragraph 29, and for the third is going to be paragraph 22. So in regards to defendants' affirmative defense 1, 2, and 10, defendants' affirmative defense 1 and 2.
You're going to have to use the paragraph numbers.
Oh, okay, that's completely fine, no worries. Okay, for defendants, paragraph 20 and 21st, they state that plaintiff's recovery is limited because of the terms, conditions, coverages, and exclusions. And then paragraph number 29 states that the plaintiff's
I can see it.
is excessive. These affirmative defenses provide no factual support, and an affirmative defense is an assertion of facts or law by the defendant that if true would avoid the action. These don't do either. For defendants, paragraph 22nd, that affirmative defense number 3, they are stating spoliation of evidence. For spoliation of evidence, the court must determine that the evidence existed at one time, the spoliator had a duty to preserve the evidence, and the evidence was crucial to the opposing party. Here, defendant has failed to allege all these elements, so we're requesting that defendant either amend these affirmative defenses or they should be stricken.
So 21, 22, and 23?
Let me make sure. It's going to be 20, 21, 22, and 29.
20, 21, 22, and 29. Okay, go ahead. What else?
Those are the only affirmative defenses.
Okay, response?
Yeah, thank you, Your Honor. As far as 21 and 22, obviously this is a breach of contract action for hurricane damage. They're seeking damages under policy of insurance. Both parties are bound by the terms and conditions and coverages of this policy. So that's the basis for that defense, because that's what we're bound by, what the policy says. In regards to paragraph 22, I don't see that in their motion to strike. So that's a new one brought forth today. I think on 22, we've stated with particularity, they waited 34 months to report the loss, prejudicing our ability to adjust the claim, and that, over 34 months, evidence may have been destroyed or damaged. I think we've pled with particularity. We put them on notice for that defense. As far as 29 goes, paragraph 29 goes is, and I'm scrolling down here. Unclean hands, we set forth that with sufficient particularity. They're asking for damages. They know they're not entitled to under the contract.
Yep, I got it. All right, Ms. Negron, response?
Your Honor and Counsel, paragraph 22, that's going to be in paragraph 5 of
You don't
our
have to. You don't have to argue. The only ones I'm interested in is, well, actually, I really don't need to hear any more argument. 21 and 22, I am going to grant the motion to strike. Those are just denials. Those aren't affirmative defenses. With regard to 22 and 29, I'm going to deny the motion to strike. So, Ms. Negron, I'll just need an order from your office after you've circulated it, sent to my office email address in Word format.
Your Honor, you had said initially 21 and.
Oh, I'm sorry. Was I confused? Okay. So 20 and 21, I'm granting the motion to strike. 22, I'm not. I'm denying it. And 29, I'm denying it also.
Okay, thank you. That was my.
Yep.
Oh, thank you, Your Honor.
Yep. Thank you.
Have a great day. Bye-bye.
You too.
Bye-bye.
All right. Next case is Scariotti versus the State of Scariotti, 19 CA 4725. Who's here for the plaintiff?
John Hooley on behalf of the plaintiff, Anthony Scariotti, Your Honor.
All right. Who's here for the estate?
Catherine Cook and Richard Mancini.
Okay. This is defendant's motion for a partial summary judgment. You guys have reserved 15 minutes, so you each have about 7 minutes. Go ahead.
Thank you, Your Honor. So the defense is moving for a partial summary judgment as to count 1 of plaintiff's amended complaint, which is a count for specific performance. This case is set for jury trial next month. The discovery has essentially been completed. I do want to start off by pointing out some procedural changes, given that the motion is now governed under the new summary judgment rule 1.510, which requires the non-movement, which in this case is the plaintiff, to file his opposition 20 days prior to the hearing today on the motion for summary judgment. As such, we did file a motion to strike plaintiff's affidavit and memorandum in opposition as untimely and believe the court should not consider those filings in its ruling today since they were filed untimely. The Florida Supreme Court, when it adopted the new summary judgment rule, specifically stated that the new rule governs any motion that is decided on or after May 1st, 2021. So clearly today's hearing is governed by the new rule. The new rule also has set out a lesser burden for summary judgment, which is now aligned with federal law. I'm sure as Your Honor is aware, under federal law, the entry of summary judgment is mandated if a non-movement fails to make a showing sufficient to establish an existence of an element essential to the non-movement's case. So even if Your Honor were to consider the untimely memo and affidavit, there still is no factual dispute here. It's really a question of law as to count 1 for specific performance. Plaintiff is seeking specific performance on a contract to purchase real property that was located in St. Lucie, Florida, whereby the plaintiff is essentially alleging his grandma, who is ultimately the decedent, and we're representing her estate, that the grandma purchased a piece of property on his behalf and that he was paying her back over the years. And it is undisputed that there is no written contract for this arrangement. We don't have a mortgage, we don't have a note. There are no writings to really indicate this transaction that plaintiff is alleging. So not only is this barred by statute of frauds, since it's an alleged oral agreement to purchase real property, really the plaintiff cannot get specific performance because he does not prove the terms of his agreement. In order to get specific performance, Florida case law requires that the plaintiff prove the existence of a contract by competent and satisfactory proof and has to prove the elements, clearly and concisely, all of the elements of the contract. I'm citing case law, which was in our motion, Miller v. Murray, found at 68 Southern 2D at 594. So specific performance is only granted where the parties entered into an agreement that is definite and certain in all of its essential elements. And that's at Bay Club Inc. versus Brickell Bay Club, 293, Southern 2D, 137, again cited in our motion. So plaintiff has this burden to establish the existence of the terms of the agreement in which he's seeking specific performance. we're set for trial next month. Discovery's been completed. Plaintiff has failed to meet this burden. Plaintiff has not established the terms of the alleged agreement. Even in his deposition transcript, which we filed with the court on April 12th, 2021, it was cited in our motion. And one of the sites in our motion is page 24 of plaintiff's depo, and starting at line 17, plaintiff is asked if there is anything in writing to indicate the alleged agreement with his grandma. And this is his exact response, a quote, "My grandmother and I had no contract." Yet he's here seeking specific performance on a contract. So he has not provided the contract terms in his affidavit. If the court were to consider it, even though it's untimely, we have no testimony or writings to indicate the clear and essential elements of the agreement he's trying to get specific performance on. Plaintiff is solely relying on charts he created. Again, spreadsheets, these types of records of alleged payments do not establish the terms of an agreement. His affidavit claims he provided regular payments. However, his affidavit contradicts the spreadsheets because the spreadsheets just show random payments being made. So really, I'm sure as Your Honor can see, it is clear that there are no definite complete terms necessary to prove the existence of a contract. We believe this is a matter of law, that plaintiff's entitled to summary judgment defendant is entitled to summary judgment as to plaintiff's count for specific performance. Plaintiff still has 2 other counts for equitable relief that he can use to try to recover damages.
All right, response?
Well, yes, Your Honor. This was filed under the old rules, and they did file this motion to strike. But, I'm not sure that they've had any prejudice. Plus, Ms. Cook has been arguing, the affidavit that we filed in this case. But I think I can make the court's job significantly less complicated. Their motion cites paragraphs 17 and 18 of the amended complaint. So I'm going to ask the court to take a look at 17. 17 says, all payments required under plaintiff's agreement with Joan M. Scariotti were completed on May 17, 2017, and she died on May 30th. That's paragraph 18. So then if you look at their motion, they're not denying that all payments have been made, and they're not denying it today. And we have the affidavit of Christopher Price. He's the personal representative. He doesn't say that it hasn't been fully paid. He just says, he doesn't have any documents indicating he's got a legal interest in the property. So,
but Mr. Hooley, here's the problem though. There is no written document that says upon the payment of XYZ amount that you'll get title to this property. And that's what's required in order for me to grant, or any jury or the court to grant relief under your specific performance count. I mean, you may have an equitable interest based on these alleged payments, but not specific performance.
Well, I respectfully disagree, Your Honor. The case of Raymond A. Dion versus Columbus Mills, 311 Southern 2nd, 681, is a Second District Court of Appeal opinion. And it says when plaintiff makes all of the payments, it no longer is an executory contract, and it's no longer in the statute of frauds. And specifically, they point out on page 683, the law of the statute of frauds applies only to executory contracts, not executed contracts. And then it says the Supreme Court of Florida has long held that the statute applies only to executory and not executed contracts. See Summerall versus Thomas, 3 Florida 298, and a couple of other citations as well. So this is a Second District Court of Appeals case. I provided it to opposing counsel prior to this, even if the court would strike my memorandum in opposition. I believe we're arguing the law here. So this was a 1975 case. There's a 2015 case from the First District. That's the case of Loper versus Weather Shield Manufacturing, 203 Southern 3rd, 898. And in that case, the appellate court cites the restatement of contracts and says it was error to conclude that the parties' agreement contravened the statute of frauds because it required the issuance of a 10-year warranty. They stated that the warranty doesn't apply because one party had fully performed. It says further, plaintiff alleged that he fully performed the contract by paying the defendant on a month-to-month basis to store and secure his boat. Under these factual assertions, the oral agreement was outside the statute of frauds, making dismissal with prejudice improper. So regardless of the issue regarding the change, the fact is the main issue before the court is the main factual issue is, was the contract fully performed? We've alleged that the contract is fully performed. They have not contravened that with any affidavits or testimony. So I would submit to the court that their motion for summary judgment is defective on its face in view of the allegations in the amended complaint. And the court needs to enter a summary judgment only if the legal allegations have been sufficiently supported by affidavits and testimony. And I submit to the court that that hasn't occurred in this case.
All right, response, Ms. Burkholz?
Yes, Your Honor.
I'm sorry, Ms. Cook. Go ahead.
No worries. Your Honor, we're not arguing statute of frauds is our basis for summary judgment of whether the contract's been completed or not. What we're arguing is that in order to get specific performance, plaintiff has to show the terms of the agreement. And I'm quoting Abundant Living City Church versus Abundant Living Ministries. It's a 3rd DCA case found at 213 Southern 3D 1055 was in our motion. But in order for the court to decree specific performance of a contract, the terms of the agreement must be clear, definite, certain, and complete. And we don't have those terms. We're not arguing whether or not the contract falls within the statute of frauds. We believe it does, but we're arguing that summary judgment has to be granted because we don't know the terms of the agreement that we could enforce.
Got it. All right, your motion's granted based on your latter argument, not the statute of frauds argument. I'll need an order from you sent to my office email address in Word format. My second question is though, why is this case why are we not, is a claim been filed in the estate? Why are we not looking at it in terms of the estate?
The requirements, Your Honor, is you file a claim with the estate. The claim denies the estate. You're required within a certain period of time to actually file a civil lawsuit.
Right, but you filed your claim in the estate, correct?
I filed the claim in the estate. The claim was denied. I was required to file a suit in
okay. Just wanted to make sure. All right, so Ms. Cook, I'll need an order after you circulated it to Mr. Hooley. Send to my office email address in Word format, please.
Thank you, Your Honor.
Thank you. All right, going back to Island Roofing versus Tower Hill, 19 CA 2895. Ms. Burkholz, where are we with opposing counsel?
Yes, Your Honor. They confirmed attendance at the hearing. They emailed me on Monday to confirm we had ordered a court reporter.
Yes, I know. Have you?
I could not reach them. I called their office. I spoke to an assistant. The attorney is not in the office. I gave him my cell phone number. I sent him an email. So I have not heard
All right,
back.
well, let's proceed then with your hearing. This is a motion to determine entitlement on a broader basis than the sanctions based on your offers of settlement. Usually those hearings hinge on whether or not the offer of settlement was correct. Anything you want to tell me about that?
Your Honor, we had served 2 proposals for settlement. I believe they were both reasonable, given our motion for summary judgment having been granted. We also believe we're entitled under our motion for summary judgment, which was a judgment on the merits of the case. They were both appropriately served to opposing counsel. We've attached all the necessary attachments to our motion, so I don't believe there's much else in the way of explanation there.
Okay, well, hold on just a second. Your offer of settlement, yeah, that's attached, and let's see.
Yes, the first was February 11th in 2020, and the second was July 29th of 2020. Both would have been attached.
Okay, I'm looking at it here. Let's see. There's a definite sum. Well, this is the first one. And you did attach a release. Yep. Okay, well, cursory review, it looked like it's okay. I'm sure that if they were actually here, they'd probably raise an objection, but they're not here. So your motion's granted. Send me an order to my office email address, but circulate it to opposing counsel first.
Okay, and that's as to fees and costs?
Yes, and I'll reserve on amount for after the appeal. But you may also want to provide that this does not affect, or this is, I'm trying to think, it's not in addition to the prior awards, but I think you might want to say this does not obviate or nullify the prior awards on sanctions.
Understood, Your Honor.
All right, thank you.
And then we will we'll do a second motion and set a second motion for hearing on reasonableness.
Right, but after the appeal comes back.
After the appeal comes back. As to the sanctions as well, Your Honor?
No, I can do the sanctions before that if you want me to, but it's kind of a wasted effort, but whatever you want to do.
Yeah, we understand, Your Honor. I'll speak to our client and we'll make a determination on that one. Thank you, Your Honor.
All right, thank you. All right, next is Catlu versus Crown Catering, 20 CA 3337. Who's here for the plaintiff?
Your Honor, Andrew Reese on behalf of the plaintiff, Catlu.
All right, is anybody here on behalf of defendant?
I am here. My name is Carly Collis. I am the defendant.
All right, the defendant is Crown Catering.
Yes, so Crown Catering was my business.
Okay.
And there are actually two defendants, Your Honor, Crown Catering and Ms. Collis individually.
Right, okay, I'm just seeing that right now. All right, so Ms. Collis, you can be here representing yourself, but you cannot represent Crown Catering because they are an entity and have to be represented by an attorney.
Oh, okay.
So they're essentially not here then. Mr. Reese,
I didn't realize that.
This is your motion. Go ahead. Motion
Yes, it's our motion for a default final judgment. The clerk's defaults have already been entered against both of the defendants. And we're here for a final judgment against both of the defendants on all three counts. We believe the damages are liquidated based on the documents that were attached to the complaint. And so we believe it's appropriate to enter a default final judgment for damages. There were three counts. Count one was breach of a lease. That was against Crown. Count two was a guarantee that was executed by Ms. Collis. And count three was actually for non-payment of a check, a bad check, also against Crown Catering. So the damages for counts 1 and 2 would be the same, and that would be the amounts that are unpaid under the lease. And the reason why we think those are liquidated is because they consist of two things. First of all, the amount set forth in the default notice that was given to the tenant before the suit was instituted, and that has been admitted by their failure to plead in response to the complaint. And then it also consists of the monthly rent that was not paid after the suit was filed. And that's actually an easy calculation based on the number of months times the amount of rent that's set forth in the lease. And we attached to our motion.
I was going to say you provided an affidavit in the motion.
Yes.
Wherein the amounts are set forth, correct?
Yes. So Mr. Eby, who's the manager of Catlu, he set forth the amount specifically in paragraph 9 for what they had failed to pay after the suit was filed. And then in paragraph 7, he attested to the default notice that was given to the tenant before suit was filed. So those two amounts total $29,149. And we suggest that judgment should be entered on both counts 1 and 2 for that amount. And then we get to count 3 for the bad check. Again, the calculation of that amount of damages is easy based on the statute and the check itself. So the check was for $2,880.90. According to the statute, you're entitled to that amount plus an additional amount of 3 times the amount of the check. And that comes out to a total of $11,523.60. So what we're asking for is a judgment against Crown Catering for $40,672.60 and a judgment against Ms. Collis for $29,149. And as you noted, the affidavit of Mr. Eby is attached to our motion and details anything that has to do with the calculation of any damages which we believe are liquidated here.
All right, Ms. Collis, is there anything you want to tell me?
Yeah, I mean, there's a lot that I need to say because I obviously, my business was a catering company. When COVID-19 struck, I was desperately trying to keep it running. I contacted Mr. Eby several times to try and work out some kind of payment plan, and he would not work with me on that. Another problem that I have is that I was unable to get into the kitchen to retrieve all of my equipment, which is a lot of money in that kitchen. The hood systems alone, the refrigerator systems are, very expensive pieces of equipment that I was refused the right to get into. So on December 31st, we were told that that was the deadline for getting the equipment. March 1st was the deadline. And I've tried several times. December 31st, I went in and spoke with Bruce. I actually said that I had another company from a very well-established restaurant down the street that was willing to take over the lease and actually give him the back lease, a back rent that was owed, so that I could kind of walk away with not being in debt. And he said that it was too late and he didn't want to accept that. And then also I called the police on the last day of February to try and gain access to the unit because the locks had been changed and I couldn't get any of the equipment out. And then he said that it was a civil matter and that he couldn't get involved. When I contacted Andrew Reese regarding trying to get my equipment out, he said that he would speak to Bruce Eby, who was the landlord, and a week later he got back to me and said that I would actually have to pay the whole of pay a storage fee. And I said, okay, so what would be
okay, let me just stop you for a minute. Mr. Reese, you can't take her equipment without proper legal proceedings. Certainly if there's a judgment and you want to levy on it, okay, but you can't take her equipment. So what's the scoop with that?
Well, she abandoned the premises. We did not evict her. She abandoned the premises. And so we took over the premises after she abandoned it. And in that premises was a lot of abandoned personal property. And we followed the statute exactly. We gave her written notice that the property had been abandoned and it was in the premises, and she was given the opportunity to claim it. But the statute
How did she abandon the premises?
She disappeared. She stopped paying the rent. She disappeared. She was not there for an excessive period of time. I think it only requires 30 days, but she was gone for a much longer period of time than that before we took over the premises.
Okay, well, I want her stuff returned to her. That's ridiculous.
Your Honor, can I just say that?
No. I
Okay.
mean, Mr. Reese, first of all, we're going to have a longer hearing on this because it sounds to me as though she had made efforts to get her stuff and hadn't abandoned it. So I'm not willing to just grant a final judgment without a further evidentiary proceeding. So you can either work it out and get your client to be a little bit more reasonable, or we can have a full trial on it, because I'm not going to grant a judgment when there's these types of allegations. But here's the thing, Ms. Collis, you need to get an attorney.
Yeah, I know. I can't afford one of those though. Yeah.
Well, I can't help you with that, and I can't do an attorney's job for you. I cannot give you legal advice. But the next time this comes up, we're going to have a full evidentiary proceeding, even though you have been defaulted because you have not answered the complaint, either on behalf of yourself or someone on behalf of the entity. So you're kind of in a bit of a pickle here, but nevertheless, if you have evidence that you in fact did not abandon this property, then you might want to bring that to a full evidentiary proceeding.
Okay, I understand. Thank you.
Mr. Reese needs to be set for a small trial, and you can set that through my office.
Okay.
So I'm just going to continue the proceeding until that time.
Okay.
All right. Thank you.
Thank you.
Thank you.
All right. Next is Corrosion versus First Protective, 19 CA 1264. Who's here for the plaintiff?
Good morning, Your Honor. Ian Ansley on behalf of the plaintiff.
All right. And who's here for defendant? Anybody here for defendant? That's not.
I don't see anyone else on the Zoom, Your Honor.
This is defendant's motion to lift the stay.
And we also have our motion for protective orders that.
Right. Okay. Well, we do that. Hold on just a second. It's 1264. Okay. What I have set, oh, this is, you know what? I looked at the wrong motion. All right, so your motion for protective order, go ahead.
Yes, Your Honor. It's a very simple motion. We are past the appraisal process in this case. The appraisal amount has been paid. The only issue is essentially entitlement to fees, which we have competing summary judgment motions. And the defendant propounded discovery a couple months ago regarding the underlying claim. So we're filing a motion protective orders to preclude us from having to answer that discovery. It's obviously an undue burden and expense.
They've filed what?
Discovery request regarding the underlying claim. Yeah, I couldn't figure it out, but that's why we filed our motion.
Okay, well, I'm going to grant your motion because, you know, without them here to understand why they did that, I really don't have much to work with. So your motion is granted in that regard. I am going to grant their motion to lift the stay.
Yeah, I had no objection to that, Your Honor.
Yeah, but only as to regard to the finalization of the case.
Yeah, just to get those summary judgment hearings reset.
Right. I think they are set. They're set in July.
Okay.
Yep. All right, so you get me an order on both, sent to my office email address in Word format?
Will do, Your Honor. Thank you.
All right, thank you. All right. Anybody else? Kathy, you had said that there was a case that you had sent me an email saying there was a case that wasn't on Jack's.
Yeah, but neither party showed up. I tried to get a hold of them last night, and they didn't return.
Why did you think it was? Why did you think it was on our docket?
Well, because it was on Showcase, and Tammy says, "Well, it's not on Jack's because there's no confirmation."
Ah, right. So they've clearly filed a notice and didn't actually schedule it.
Correct. So we still have to accept them. And I didn't know if there.
Okay.